Hello and welcome to the final edition of Van Winkle's series of Facebook Live presentations for this year. For today, Brian Lawler and I'm John Kelso, both members of the firm's Trusts and Estates group. We will be talking about firearms law as it relates to estate planning and estate and trust settlement, and in particular, a certain type of trusts, usually referred to as gun trusts. So first, the usual disclaimer that we append to these presentations, that this is about general North Carolina law and federal law based on our own experiences and research, and this presentation should not be considered legal advice to any specific person or for any particular situation, because all of these things are very fact specific. So if you have a question about your own certain circumstances, please do consult with a qualified attorney. So as I mentioned today, our topic is on firearms law and gun trusts. We will be covering some basic background law, the federal law that applies, as well as the North Carolina state law, and giving some advice just about setting up an estate plan that for people who own firearms, and if you are the executor or trustee of a situation that involves some firearms, some guidance about things that you might want to consider. So I think Brian is going to lead off with a little bit of background on the law, and then I will come back and talk more about estates and estate planning.
Thanks, John, and welcome again, everyone. Thank you all so much for joining us in this our next session. So unlike a lot of the estate planning and administration issues that we've really talked about in this series kind of to date, which are primarily governed by state law, almost exclusively governed by state law, with the exception of some federal tax issues, and we get into some federal law issues every now and again when we're dealing with sort of estate planning and estate administration, but a lot of that is largely governed by the state and state legislation. Firearms are kind of one of the exceptions to that rule. It is heavily regulated and governed by state law, don't get me wrong. But the federal law is also very much present in the regulation and licensing and transferring of firearms from one generation to the next, or from one person to the next. And so you really have to, when considering a plan, an estate plan that's going to involve really any type of firearm, but as we'll talk about, even specifically some kind of a subset of specific types of firearms, you really have to take into consideration, and we really have to take into consideration, not just state law regulations. In some cases, even local municipalities, even the local county can have different regulations than what from county to county. And so you really have to look at it not just from your county and your state, but you also have to take into consideration federal law. And that's true whether you're transferring, or maybe you own, dad's old rifle, one firearm that maybe has been maybe even passed down to you, or that you've used for hunting, or you have, a collection of firearms, some of which may call an arsenal, but you have a collection of firearms in your possession, and that maybe you've developed over the years. And so that's going to be true. Looking at state and federal law is going to be true regardless. So state law, just kind of touching on that a little bit, there is a significant section in our state legislation devoted to firearms and firearm regulation. A lot of it deals with primarily who can own a firearm, under what kind of circumstances a person can own a firearm, or under what particular types of firearms can be owned under certain circumstances. So as an example, we have what's called the North Carolina Felonies Firearms Act. And essentially it's prohibiting the possession of any sort of firearm by a person who's been convicted of a felony, in a state felony in the state of North Carolina. In addition to that, there are other, there's a host of regulations, but some of the other big ones relate to age requirements. North Carolina generally defers to federal law when it comes to the age requirements of owning a firearm, but essentially, if you want to purchase and own a handgun, revolver, pistol, something along those lines, you have to be 21 years of age or older. But if other types of firearms, rifles, shotguns, sort of things that are typically used for hunting, you have to be 18 or older. For the most part in North Carolina, a person can obtain and own a variety of firearms, including automatic firearms, short-barreled firearms, other explosive devices, all kinds of things. There's not really a heavily I mean, there are federal restrictions on certain types of firearms that North Carolina complies with, but for the most part, a person in North Carolina can own just about any type of legal firearm, but they have to comply not just with state law, but federal law as well. Handguns and pistols are one of the types of firearms that does require something a little bit special. It does require either some sort of permit in order to purchase or possess that firearm. That's typically done through what's called a pistol purchase permit, which is a lot of P's, but essentially means that you've gone and you've obtained a permit from your local sheriff's office to purchase a pistol or a handgun. Also, if you've gone out and obtained, gotten the concealed handgun concealed carry permit, then you can use that permit as well, authorizes you to purchase a handgun. Generally, though, registration of the gun is not required, but a permit to acquire it is required. And then, like I said, there are local municipalities who have imposed other regulations. So it's really important that you check with your local sheriff's office in the county in which you live before you go to, I mean, you're gonna have to probably anyway, but before you acquire a handgun, because there may be some specific rules surrounding that. On the federal law side, there is a similar, as I was talking about the North Carolina Felonies Firearms Act, there's a very similar type of legislation on the federal side that does set those age requirements and establishes a variety of prohibitions against who can own, transfer, and possess a variety of firearms. One of the biggest acts that you'll see if you Google gun trust, the thing that's going to come up almost at the top is going to be something related to what's called the NFA, or the National Firearms Act. National Firearms Act was enacted back in the 30s and has been reviewed and updated a number of times. Originally, it gave Congress the authority to tax the transfer and possession of certain firearms. It was really intended to curtail ownership. They wanted to prevent people from purchasing guns. And so what they did is they imposed a $200 tax on the transfer, or anytime you would purchase or transfer a firearm. Well, in 1930, that equated to about $3,700, which was very cost prohibitive for a lot of people. Interestingly, that transfer fee has not changed since the 1930s. And so it is still $200 to get your transfer stamp, which for most people now is not as cost prohibitive. And so anyway, so that number just hasn't changed. The NFA was updated in the 60s in 1968 through what's called the Gun Control Act. It was actually passed, sort of interesting history here, it was passed in the wake of the assassinations of John F. Kennedy and Robert F. Kennedy and Martin Luther King, and was intended to impose stricter laws concerning the regulation of firearms, licensing of firearms, possession of firearms, et cetera. Again, it was updated again in the 80s with what's called the Firearm Owners Protection Act. And again, all of this matters because when we're going to talk about sort of quote unquote gun trusts, or we're going to talk about specific types of tools that you can use in planning for firearms in an estate plan, the term NFA gun trust or Title II guns or firearms comes up a lot. And so I wanted to give you some context of what do they mean a Title II firearm? Well, that relates to Title II of the Gun Control Act from the 1960s. What is the NFA Firearms Act? Well, that's relating to legislation that's been around for almost 100 years, but it defines specialized types of firearms that John's actually going to get into. So that kind of gives you a little bit of like where we are. It's kind of the context of what we're dealing with. There is state laws that are necessary. There are federal laws to be considered. And now that we've gotten that boring lawyer stuff out of the way, John's going to talk to us about how to actually deal with some firearms and things that you need to consider when dealing with them, both in the planning and in the administration, what happens after you die side. So, John?
Thanks, Brian. Yeah, I think that the history of the NFA that Brian mentioned is particularly fascinating because, like you said, it's part of the tax code. It was enacted as a tax, and as Brian mentioned, while the transfer tax on transfer of one of these so-called NFA firearms, a particular type of subset of firearms, while that tax is only $200, the penalty if you don't file it and pay the tax can be tremendous, and a felony in addition to the monetary penalty and prison time and all that. So it's interesting how they enact a relatively small tax these days, but the penalties for failing to comply are quite serious. And just sort of another aspect of that being part of the tax code, that up until fairly recently, the enforcement of that was under the Department of the Treasury, and under the Department of the Treasury, under the Bureau of Alcohol, Tobacco, and Firearms, the ATF. But then as part of the post 9/11 Homeland Security Act, the ATF was taken out of the Department of the Treasury and moved to the Department of Justice. So it's kind of an interesting look at how some of these laws trace back historically and then change as they come forward. But moving on, so in terms of actually planning for an estate, you want to think about who you are leaving these firearms to, because there are some limitations on who can possess a firearm. So if it's just a regular long gun, a rifle or shotgun, not an NFA firearm, then as Brian mentioned, you can't be a minor and own it, although it can be held for a minor by an adult until they reach 18. And it cannot be possessed by somebody who has been convicted of a felony or just under indictment for something that is punishable by more than 1 year. So even if you have a plea, if the offense was something that could have been punishable by more than a year, then you cannot own a firearm, unless that is somehow, if you have served your time, you can have your rights restored. But so in the estate planning world, another area where you cannot be a convicted felon is you can't be an executor of an estate, period, if you are a felon. However, if you have had your rights restored, then you can be an executor of the estate. But in the case of possessing a firearm in North Carolina, that taint of the felony persists for 20 years before you can apply to be able to possess a firearm. Other categories of people who are prohibited from having a firearm transferred to them or possessing one is if you are an unlawful user or addicted to a controlled substance. And of course, the federal definition of a controlled substance is a little different from some states, particularly those that have allowed legal marijuana. An alien who is unlawfully in the United States cannot possess a firearm. People subject to a restraining order for certain types of domestic violence situations cannot possess a firearm. And certainly if you've been convicted of a domestic violence crime, you cannot possess a firearm. So I'm not sure how awkward it is to go around and ask your potential devisees that you want to leave a firearm to if they've been convicted of any of these things. But, that's sort of a joking comment, but if you're in the position of being the executor, how do you know whether any of the people who are beneficiaries of the estate may have, within the past 20 years, been convicted of something like this, or be addicted to a controlled substance? So, there is certainly some risk of not only planning it, but being the executor. And by the way, a lot of those restrictions on who can possess a firearm or who you can transfer a firearm to are really similar under North Carolina state law as well as the Federal Gun Control Act, not the NFA, but the sort of broadly applicable Gun Control Act. Similar, but not always exactly the same definitions. And as Brian mentioned, pistols or revolvers have their own restrictions in North Carolina, that you have to have a concealed carry permit to possess that, or just to possess it, you have to have a license from the county sheriff. I think that, in fact, I looked that up, and in the days of COVID, like everything else, I think you can apply online for that sort of thing. It's a fairly quick turnaround, but it is the kind of thing where you have to have that permit from the county sheriff. So that's on a county by county basis. I think a lot of, in naming who you were thinking who you're going to name as the executor of your estate or the trustee of your revocable trust, think about who would be comfortable not only taking possession of your firearms safely, but storing them until they can be distributed and actually doing the distributions. And that, of course, may depend on where that executor lives. There are issues with crossing state lines, or certainly mailing firearms across state lines. That can be a problem. Think about who the executor is going to be and whether they're going to be comfortable taking on those responsibilities. One of the other issues that Brian will touch on later, which is a reason for a gun trust, is dealing with situations where that duty to maintain the possession and control of the firearms is non-delegable in a lot of cases. So the executor cannot just say, well, I'm uncomfortable or don't have a place to safely store those, so I'm going to turn them over to somebody else to store on behalf of the estate. That can be a serious problem. So a lot of things to consider there, both in the planning side and in the administration side, if you're an executor. I think certainly the executor of an estate would want to have the recipient of any firearm sign something indicating that they are not one of these restricted classes. They are not in one of these categories of people who cannot possess one. If you're the executor, you want to have something showing that you have tried your best anyway to verify that the person you're giving this firearm to is allowed to possess it. If you want to go, and of course, if it's a pistol, that they have whatever kind of permit is required, either from the county sheriff or a concealed carry permit. If you want to go a little farther than that and be a little more careful, you can use a licensed dealer, and in particular one that has a federal firearms license, which is something that I think Brian might touch on, that they have to sign up for, and it's fairly stringent requirements. You can use a federal firearms license dealer to help you with that transfer of the weapon from the estate or trust to the recipient, and filling out some paperwork to go along with that, because there are some federal forms that, even though they might not be required in the case of just a hunting rifle or a shotgun, they can be used. And I think if you're the executor and you want to be particularly cautious about the distribution, that would be the safest way to go, is to have the FFL dealer handle that for you, fill out the paperwork for you, and even then handle the delivery of the firearm to the recipient, which might include mailing it. Depending on the available time we have left, I might come back and touch on some of the restrictions on mailing, whether it's within North Carolina or across state lines, whether it's Postal Service, one of the other delivery services, et cetera. But let me mention just a couple of things about specific firearms to watch out for. A lot of these rules are based on the length of the barrel or the overall length of the firearm. A shotgun with a barrel of less than 18 inches or an overall length of less than 26 inches is more tightly regulated. That is an NFA firearm and is in a different category under North Carolina law. And a rifle with a barrel shorter than 16 inches or an overall length of 26 inches, likewise, is subject to much greater restrictions and much greater risk and rules in terms of how the executor deals with that firearm. So Brian, let me turn that back over to you to talk about gun trusts.
Yeah, thanks, John. So I would say, and I'll share this quick kind of anecdote. You were mentioning that, sort of the irony of the sort of interesting history about the state, the Department of Treasury. I have an uncle, a great uncle, maybe my mom's great uncle, family member who has the unfortunate distinction of being one of the first people killed as he worked at the FBI. He was killed in a shootout. And the interesting part about that is that he was, at the time, the FBI was under the Treasury Department. But anyway, so he was under the Treasury Department, and they weren't allowed to carry firearms. With the FBI, the early FBI folks were not allowed to carry firearms, and so he was got into a shootout with some mobsters in the 1930s in Chicago, and couldn't return fire and was killed. But that has since changed in the FBI. If you work for the FBI now, you can actually carry a firearm. But anyway, I thought that was an interesting anecdote. So it has nothing to do with firearms or firearm trusts, which I want to talk to you about now. So essentially, we're looking at, I'll just touch really briefly on a non-NFA trust, why you might have a non-NFA trust. And really what that is that it's just like any other sort of revocable living trust that deals specifically with a firearm that you may have. It's not an NFA firearm, it's not regulated under those rules, but you may have a provision in your trust document, maybe the revocable living trust that you have, or if you don't have a revocable living trust and just have this one firearm that you want to deal with, you might have just what's considered a non-NFA firearms trust. Again, it has a lot of the same advantages that normal trusts do in terms of privacy and ease of transfer from one generation to the next. But it may include, and probably would need to include, some additional requirements of the trustee to ensure that the beneficiary of that firearm upon your death is not a prohibited person and can own a firearm. So again, not to belabor the point, but it's just something that if the only firearm you have is a hunting rifle, and you would like to leave it to your son, who may be a minor right now or may not be, and you have a trust, you may consider a separate provision in that trust dealing specifically with that firearm and some of the considerations that the trustee may need to take. So NFA trusts or gun trusts, which we hear a lot about, essentially what's the skinny on them? Well, why would you even want a gun trust? As John mentioned, there's different types of what's considered NFA, sometimes called Title II firearms. These are things like short-barreled shotguns or rifles. Another common one is a silencer or a suppressor, some sort of device that you attach to the end of your firearm to suppress the sound. And in addition to the suppressor, any parts that are made that go into the creation of the suppressor are also classified as NFA firearms. Machine guns, as long as the machine gun was produced before 1986, can be owned and possessed. Machine guns manufactured after 1986 are prohibited outright. Other automatic firearms are firearms that could be made automatic. That maybe is semi-automatic that then gets changed and becomes an automatic firearm. And any of the tools that you might use in order to make that happen would be considered an NFA firearm. Various destructive devices, bombs or grenades or things.
Brian,
yeah.
Let me interrupt you a minute. Your sound is messed up right now. We can hear you, but it sounds funny. Wasn't sure whether it was just me.
Okay.
I don't know if there's anything you can do about that, though.
No, either. Let's see. Maybe I'll try to talk closer. Is it making any difference right now, John?
Nope.
No. All right. Well, maybe, let's see.
I can still understand you. It just sounds odd.
All right.
Go ahead. Now I can hear you at all.
Okay. How about if I just...
That's good.
Okay. All right. Maybe I'll just talk a little louder. Maybe I just had to switch it up. So there are a variety of other types of devices. There's a category called any other weapons as well. And those are really odd kind of collector things. Examples that they are often used are umbrella guns. It sounds very 1990s Batman-ish, or the Penguin, I think, had an umbrella gun. That would be an example of an any other weapon. So if you own one of these weapons or you intend to acquire one of these weapons or firearms or devices, then you may want to consider utilizing a firearms trust to actually own and possess that firearm. So some of the advantages are like other trusts. It allows a continuity of control and ownership in the case of you becoming incapacitated or your death. It allows you to avoid probate and not have to have the public disposition of those firearms, which you may not want the world to know about your firearm collection. But one of the big ones, there's two big ones. The big one is it helps to prevent accidental felonies, which is what John was talking about earlier, where possession of an NFA firearm, if you are not a registered owner or in this case a trustee of that trust, is a felony. In fact, not just owning it or possessing it, physically possessing it, but even having what's called constructive possession. If you know where it is and you could go access it and you're not registered to be able to own it or access it, you are committing a felony. If you transfer that firearm from one person to the next and that person is not entitled to receive it, that's a felony. So there are a lot of huge potholes that could really get you into a lot of trouble if you're not careful. And so a gun trust helps to avoid a lot of those. The other is it allows for the transfer of the firearm to a variety of people who may be trustees of that trust without incurring a $200 transfer tax every time you're giving it or loaning it to someone to borrow. So it allows someone to purchase a firearm or a tool or a mechanism like a suppressor, and it allows multiple people to utilize that instrument without transferring it from person to person to person. And that's another big reason that people oftentimes will utilize a firearms trust. So real simply, the way that it works, and I won't go into too much detail, but essentially you've got it set up like any other trust. If you're an owner, you will set up that trust. You'll identify who the initial trustees, kind of the big trustees or the managing trustees are. These are the people who are going to have regular access to the firearms. They're going to be able to have possession of them. They're going to be able to sell them out of the trust or receive new property into the trust. They're kind of the primary trustees or initial trustees. You can also have other types of trustees in a gun trust. One of those is what we call a special trustee or a temporary trustee. And this is a person who you've named on a very temporary basis to have the ability to utilize the firearm and to have access to it, but not on a permanent basis. They can't manage it. They can't sell it, they can't get rid of it, but they can use it. And so an example of that, and one of the examples that I see often is, I'd say the story, I had a guy come in a couple years ago and he was looking to purchase a suppressor. And of course, I didn't, at the time, didn't really know what, I only had seen them on TV. Why would you buy a suppressor? And what do you use it for? And it turns out he was going boar hunting out in Texas on a huge ranch and used an AR-15, which is a very powerful rifle, to boar hunt. But those rifles are very, very loud and they scare the animals away. And so a suppressor was added to the firearm for the purposes of spreading the sound out. And so when they shoot with the suppressor on, the boar can't tell where the noise is coming from, and they don't scatter. And so a suppressor can be really important or essential to hunting boar in Texas. So he wanted to acquire that suppressor, but he also was going to go with some buddies and they were all going to go boar hunting. And he was going to be the one who was going to actually purchase the suppressor, but he wanted to be able to have his friends be able to utilize it. So he set up the trust. The trust actually acquired the suppressor. It actually purchased the suppressor, the trust did. And then he was the sort of managing trustee, for lack of a better word. He was the one who actually owned it. He could possess it. It was at his house. But he named his buddies as special trustees for the limited purposes of that trip. And while they were there, they were able to utilize the suppressor. But when they came back home, they didn't have access to it anymore, and they were no longer trustees. It was for a limited purpose. Now, the one thing I think is important to mention, because we're running out a little bit of time, is that in order to be a trustee, in order to be a special trustee, a temporary trustee, any type of trustee of a gun trust, there are certain steps that you have to go through that are not simply just, signing a piece of paper saying I'm a trustee now. There are forms that have to be filed at the ATF. You have to submit fingerprints. So there are some steps, but they're not, very arduous and can easily be accomplished in a relatively short period of time. The other thing that's really important as well is that the trust that is going to own or possess the firearm also needs to generally be reviewed by the ATF and approved as well before a dealer is going to sell it to a trust. But the trust itself can actually acquire the firearm, and oftentimes that's the best approach in order to save a couple $100. If I go and buy the firearm and then transfer it into my trust, I've paid $200 for me to get it and another $200 for it to go into my trust. The trust itself can buy it directly, and it saves a couple $100. So if you think that you might be acquiring a firearm like this, I think it's the moral of the story here is, come and really probably should consider talking to someone other than, the legal authorities on Google, and really think about, who's going to own it, how it's going to be possessed, how it's going to be dealt with in the case of you becoming incapacitated, or what happens after you die. Because you could get yourself certainly, or your loved ones, into a lot of trouble, unintentionally and inadvertently. So I think
I think I neglected to mention one piece of advice for executors or potential executors, which is, if you are not familiar with firearms and what may be an NFA regulated firearm and what's not, or what parts or other equipment like a suppressor may be NFA regulated, find someone who is, because it is the duty of the executor to figure out what type of firearm or other equipment they're dealing with, figure out what the regulations are, figure out whether they have to go through an FFL dealer or file all of these ATF forms and pay fees and fingerprints and all that, or whether it's the more simple, just the state law, get some assurances about who the recipient is and off you go. It's your responsibility to determine which restrictions apply to which firearms. So that's a big potential trap for the unwary.
Yeah. So as you can tell, there's a lot of sort of regulation. There's a lot of real specific issues and legal issues that go into managing firearms, both in an estate and just owning them generally, but certainly in the estate. So certainly our advice would be to have a conversation with an attorney who has some understanding of the specific aspects of dealing with firearms in an estate plan, rather than trying to go at it on your own, because there are so many potential pitfalls. But want to thank you all so much for joining us on this next session. On this session, please join us again on Thursday, same time, same place, for our next session. And certainly, if you had questions, or you have questions, you're watching this on replay and you have questions, certainly comment below, and we will do our best to respond in a timely manner. So everyone, have a great day, and thank you so much for joining us.
Thank you.